This week we're going to discuss chapters 50 and 51. Chapter 50 is about employment law. For the past 48 years, Title VII of the Civil Rights Act of 1964 has prohibited employment discrimination based on race, religion, sex, or national origin. Any employment decision, including hiring, promotion, and discharge, based on one of these factors is unlawful and subjects the employer to an award of back pay, promotion, or reinstatement. The Equal Employment Opportunity Commission, or EEOC, may file suits, as may the employee, after the commission screens the complaint. Two major types of discrimination suits are those for disparate treatment, in which the employer intended to discriminate, and disparate impact, in which, regardless of intent, the impact of a particular non-job related practice has a discriminatory effect. In matters of religion, the employer is bound not only to refrain from discrimination based on an employee's religious beliefs or preferences, but also to accommodate the employee's religious practices to the extent that the accommodation does not impose an undue hardship on the business. Sex discrimination, besides refusal to hire a person solely on the basis of sex, includes discrimination based on pregnancy. Sexual harassment is a form of sex discrimination, and it includes the creation of a hostile or offensive working environment. A separate statute, the Equal Pay Act, mandates equal pay for men and women assigned to the same job. There's a lot to cover in Chapter 50, so we'll go through all of these topics. Chapter 51 is about labor management relations. Federal labor law is grounded in the National Labor Relations Act, which permits unions to organize and prohibits employers from engaging in unfair labor practices. Amendments to the National Labor Relations Act, such as the Taft-Hartley Act and the Landrum-Griffin Act, declare certain acts of unions and employees also to be unfair labor practices. The National Labor Relations Board supervises union elections and decides in contested cases which union should serve as the exclusive bargaining unit, and it also investigates allegations of unfair labor practices and provides remedies in appropriate cases.